was directed to be listed on 20th of January, my lords.
That's the difference. Really big. You have is it assigned to this court?
No, my lords, it was being heard on 2-3 occasions.
No, that may be, but it has to go to the consent bench.
My lords.
Consent bench only. I thought it is assigned to this court. Okay,
My lords had heard it on 3 occasions.
it's all right, but still, if modification in anything, then I can hear. Otherwise,
No, there's no IA pending.
thank you.
Oh, my lord.
Yes, yes. Any mentioning? Okay, start. Mentioning? Yes.
Lord, item 58 on behalf of Ms. Subhashri.
Uh,
Kindly it may be urgent to.
let it be there.
Minor.
Okay. I'm not adjourning any matter. This is weekly list. I'll pick up the matters and yes. Yes.
Item 1.
Lordship, for modification, your lordship.
What modification?
Directed last para, your lordship, in criminal.
Last the 11/11/25 order.
Yes, your lordship. Last para, lordship. In view of the foregoing discussions, the conviction of appellant 320 affirm the order of sentence is modified. The appellant so and so is really 1 month time has been granted, your lordship, due to communication gap.
Sorry.
Entering into a bond of goodwill and conduct in sum 5,000 in one surety for the like amount. Within 1 month.
month. What
That may be extended, your lordship, to some more period due to communication gap.
Okay. The appellant has moved this present application seeking modification of the judgment dated 11/11/2025. The learned counsel for the appellant submits that 1 month time was granted to the appellant to furnish the bond under provision of Offenders Act. However, inadvertently, due to communication gap, the same should not be conveyed to the appellant. NCC seeks extension of the time. Regard being held to the submission made by the appellant and the reasons stated in the application, the appellant is allowed 1 more month time from today to furnish the bond as per the judgment dated 11/11/2025. Okay.
Item 2.
I'm sorry, can I make it? I'm
Yes.
late because of the.
Yes.
The item number, the government appeal, I think the state minute also ready.
Hmm.
I have got personal difficulty. I know that's very old matter.
Uh-huh.
I am in the government appeal.
Next week. Next
Not next week. I want a little longer time because for 2 months I will go for a post-operation checkup outside India.
Okay.
And for this 1-2 months, I don't think that I can take up a heavy matter.
Which year matter that is?
90. Yeah, that's for 90. GA number 37.
For various.
Okay, let it be there. I'll accommodate you. Don't worry. Don't worry about it.
From May to June, I will be absent in sometime in July, madam, with all respect, because.
So no, July I can't because the problem is the report has to be submitted to the Supreme Court.
But because my problem is this, madam.
That's right, but report has to be submitted every month.
Yes, I know. That's what in the beginning I said.
Otherwise, there is no.
And many delay is not because of us, because of the patency.
But all the appeals of 90 has to be disposed of.
I understand.
Before it should be March or max to max.
Your lordship may accommodate as far as possible, madam.
I'll retain it.
Madam.
We'll see. Or otherwise, you give written note of submission. I'll deal with it.
It needs hearing because the government servant is there. Otherwise, I would not have been conscious.
Ask your
Government in equitable government has filed the appeal. Even they are also. I don't know whether some your lordship asked for a report that they are alive or not. The report has come that they are alive. The respondents.
If you can make an alternate arrangement, it's all right.
Now that's what I'm trying.
Then let it
But
be
let
there.
it be there.
Is item number
90.
90, yeah?
90.
Little bit as far as possible, my lord, can adjourn the matter.
Round up करके रखता हूँ.
I'm
Whenever it
getting
comes,
better day by day. I can
Relax,
assist your lordship.
I'll take care. Don't worry. 95 matter. That's another problem. Yes. Anyway, we'll see. Yes. Next.
Item 2.
Item 2.
मनो को कह दो 19 के पास. Yes. 2. Yes.
Motivation.
What happened? Modification? What modification?
The bail has been granted.
Huh?
But they filed on 16/1/2026.
Okay.
Bail has been granted subject to 40,001 local claims, shorter claims. But then they filed the IA for the modification, but the part modification, the IA copy. has-
Okay, then APS, release the matter after 2-3 weeks. They do.
Other-
Adjourn. Bail matter is no.
Item 3,
Modification of
Yes. Yes, what happened? What was the application?
One.
That condition.
Okay.
Okay, that condition.
Last time
You said there are 2 cases.
two
Can you
cases.
give?
Yes,
give-
and as a affidavit मध्ये.
One case has been accepted.
One case is pending.
The same thing he is also saying.
My lord, my.
Same thing he is saying. It's not similar kind also.
Yeah.
Okay. Have I recorded that you have said no criminal case injury? See para 4, just see para 4, come to para 4. Para 4 of the order dated 3/2/2026.
3-2.
By which the bail has been granted to you.
Type 126.
Huh?
Type 126.
No,
5/126.
5/126. Okay.
Yes.
Para 4. Read last line. Last line.
Mr. Dwivedi, London.
Mr. Dwivedi
Submit that.
further submits that petitioner has no criminal antecedent
Sit
and
down.
he is in custody since so on. You made this statement.
Okay.
Therefore, this order. Now 2 cases are coming.
File the affidavit.
Yeah, affidavit now you filed. Then you have misled then.
No, not misled.
Then?
Do not able to get
So
instruction.
then why are you making those kind of statements?
Sir, କହିଲେ କିଛି
And for the
ନାହିଁ।
purpose of pursuing the court
No,
for granting bail, you make any statement
ସିଏ
and get away with this. This is High Court. You make a wrong statement, obtain an order, and thereafter you say that no, the statement was wrong. But you got the, then you can't make those kind of false statement and get away with this. This is after all High Court proceedings. Okay, High Court proceeding. How will you deal with it?
The client may suffer, my lord.
Huh?
Client may suffer, my lord. See, he instructed me.
You filed the affidavit, he instructed you. You made very specific statement. I have recorded it. Mr. Dwivedi further submits that the petitioner has no criminal entity. That was the reason I got persuaded to grant you bail. And now you are saying that 2 cases. 1 case he is acquitted, another case is pending. It's very easy for you to say that let the client suffer. But what
My
happens?
lord, we have no direct access to the client. The law and trial court advocate communicated us. Accordingly, we made statement.
And we are playing with the liberty of someone. So I can't set my eyes and ears.
Man, this is the
He's
fact.
entitled to bail.
This is the fact. It's a case of 354B. I had no intention to make a false statement.
Then you file an affidavit that I'll give, because he is entitled to bail. Therefore, I'm saying. You file an affidavit on wrong instruction given by so and so, it has to come on record. I made that statement, I'm withdrawing that statement to me. Then I'll grant the bail. Because of the
Can I
mistake,
file-
why should he remain in the jail?
Can I
That's another problem.
Passover, can I file today?
You can file 2 o'clock. File an affidavit. Then therefore I'll record it that Mr. Dwivedi made the statement on the basis of instruction, which was wrong. He have filed an affidavit to that effect. So that portion I'll remove, then I'll grant it. Okay? Record has to be kept. Yes. And henceforth, please
Okay.
don't make those things.
This-
Okay. Okay.
2 o'clock. I will.
2 o'clock.
hearing. Item 4,
Again, HS means the problem, 94 matter.
I do think,
Hmm?
94 I think touch, but it's okay.
Amrish Mishra. Have you noted down at the top?
Yes, sir. 95. There was 95, 97.
No, it will self-declare. No, I said that if nobody appears, appoint amicus curiae.
Where? Of course.
That you noted down. I'll just pass over, otherwise, somebody else has to, Amrish Mishra, last time appeared.
Used to ask me.
Hmm?
Used to ask me. Nothing.
16, 12, Mr. A. Mishra was appointed. as
Ambrish
amicus.
Mishra is appearing.
Amrit. 16?
16, 12, 25.
16, 12, huh? Okay. Amrish Mishra is conflicting. He appointed amicus curiae is not coming. What? I'll just call it. Pass it over, otherwise I'll appoint someone. Yes. 94. Next.
Item 5,
Yes, sir.
May I please?
File.
My lord, here, my lord, the three accused persons, they are convicted under section 304, part 2, and sentence for 5 years.
Okay.
Your lords, you have a glance, the last order, that is the order dated 29/10 to 2014.
What? 14?
Yes, my lord.
What is
In
the date?
fact, 29/10, 2014.
Yes.
So far as the appellant number
Pursuant to
1
the
is
direction of this
concerned,
court dated so and so, the appellant number 4 has been apprehended, and this was determined during the pendency of the appeal. Appellant number has died. And appellant number 2 has lost his mental balance, and appellant number 3 has been released on bail. And since he has already undergone 5 years of imprisonment. Considering this application made, I direct the appellant number 4, Holku, so and so shall be released on so and so. Then
in fact, my lord, appellant number 3
3
has already undergone the period, my lord.
appellant number 3 undergone period, huh?
Yes, ma'am. 1 is dead.
A3 already undergone. A3 already. Yes. And sentence. A1 died, huh? A1 died. And who is mental patient?
Yes, my lord.
A2. A2 mental.
Yes, sir.
A2 mental patient. Mental patient. Then who remains? A4.
A3, my lord.
No, A3 already undergone.
Undergone.
Forget it. A4. Who was granted bail? Halko.
Yes, ma'am.
A4. Yes. Halko is gone. So what is the sentence?
Sentence 5 years, my lord.
304, 5 years. Halko has undergone how much?
A4.
Hmm.
A4, my lord, in fact, I have not.
Just take it. A4, how much he has undergone?
I have not, I'm not in contact. That is the whole problem.
No. You can find out the period undergone from there. When he was arrested, because see, he was granted bail by this court on 29/10/14.
2014.
14, huh?
Yes, ma'am.
So when was the judgment? Judgment was pronounced on 2094, 21/194 judgment, isn't it?
Yes, sir.
जजमेंट है
194.
22/1/1994. It was granted bail on
29/10/2014.
29/10/2014.
Yes, sir. One.
He might have already undergone.
Yes, that is the report. Your lords may call for a report so that it can be.
A call for the entire thing is here. Where from I get the
From the record, it appears that he has
all
already.
of them might have already
90.
undergone the period of sentence. Just see the order dated 29/10/14. Issue. Okay, issue non-bail warrant arrest against the appellants, namely Molto. Oh, no. They were not arrested on that day. See the order dated 25/7/2014. Issue NBW. They were absconding. Directed to take instruction of the NBW, not executed. Okay. They were not taken into custody. After the conviction, they were not taken
Yes,
into custody.
that is the.
NBW was issued by this court. Thereafter, bail was granted.
25/7 to 2014.
2014. During trial, just check it up. During trial, he was taken to custody on charge sheet. Just see the charge sheet. Halku, and we are talking about Halku and two. Who is two? Is a mental patient.
Which good man? Yes.
Good month.
Yeah, he has also completed 5 years.
Who?
Appellant number 4.
Where? Hmm.
I have noted down in a place, my lord, must have been some.
The problem is scanning is so poor, very difficult. Just see from the charge sheet when he was arrested. IO statement, just see. Then statement of IO when he might have said. Who is IO?
PW10.
Just check it up. When he arrested. Has he said anything? PW10, huh?
Yes.
Just check it up. No, he took subsequently. Who is J. Monto?
PW8 and pen.
8, just see 8. Who has arrested them? No, I don't think so.
Date of apprehension is 11/6/1991.
11,
6/1991.
1991.
Yes.
They were arrested, huh?
There is a document, calendar of information. In that document, it has been mentioned.
They were arrested on that day.
Yes.
11/6. Okay. And when the bail was granted, just see proceeding. Order sheet of the trial court. See the order sheet of the trial court. See, first order is Udiye no 20th to 1992. Accused persons are in jail custody. Okay? Accused persons are in jail custody. 92. Accused persons are in jail custody. Accused persons are produced under custody. Okay? Accused persons jail. Ajira and so on so. Produced under jail custody. 92 jail custody. So today.
The order dated 26/6/92 says other 3 accused persons are on bail except Halku.
Huh?
Order dated 26/6/1992.
6, 26/6.
Yes.
Hmm.
Accused Halku.
Accused Halku on the produce in jail custody. Other 3 accused persons who are on bail in view of the bail order passed in the Honorable High Court. Okay? So Halku is 4, huh? Halku is 4. Halku is 4, na? Then when he got bail, just let us see. Halku, accused Halku produced into jail custody.
Ticket.
You have to search it. I'll just pass an order. You verify. I'll just record it. Write down. From the record, it reveals that insofar as appellant number 1 is concerned, he has already died, and the appeal qua him stood awaited in the absence of any application under section 394 CRPC, either by his LR or next friend. Insofar as appellant number 2 is concerned, it appears from the record that he has lost his mental balance. Balance. Appellant number 3 has already undergone the entire sentence awarded to him. In so far as appellant number 4 is concerned, the it appears from the record that although he was taken into custody on 11/6/1991, but when he was granted bail is not could not be ascertained, Therefore, the State Council seeks an adjournment to ascertain this aspect of the matter. Let the State Council obtain a report regarding the mental health condition of appellant number 2 and the period undergone by appellant number 3, appellant number 4. Leave the matter on next Thursday. These two things you tell me so that we can dispose it up. And from insofar as 2 is concerned, his mental health condition you just verify, and 4 you tell me the period undergone. So we'll dispose it up in that. Okay, Thursday. मैं साथ रख दो without fail, please do it. Otherwise, it will remain. Yes.
Item 6. May I please?
Yes.
Discuss my lord. There are about two, admitted there are 2 appeals, my lord. All total, my lord, 5 accused persons face the trial, my lord. All of them convicted. The appellant number 1, Popu alias Joynaran Munna, he has been convicted under section, my lord, 376 and 366 of IPC. And sentenced to RI for 7 years so far as 376 is concerned, and 360 4 years, my lord. And the other accused persons, my lord, who have faced the trial, they have convicted under section 109.
Two has died.
2 had died.
2 has died, and now 1, 3, and 4. Okay.
And another, my lord, another, my lord, appeal referred by another co-accused, my lord, that is
Sardul Baga.
another appeal, one
Sardul Baga. Separate appeal.
separate appeal, he has been, my lord, awaited that since he had died.
He died. When?
That is order there, my lord. Your lordship passed the order.
Dead. Okay. Awaited. ठीक है.
126/94 awaited.
Okay.
So 2, my lord, out of 5 to against 2.
So this appeal go stand awaited. Okay. Now only 160 is there.
160. Appellant 2, my lord, awaited. So far, appellant 2 is concerned.
And therefore 3, 1, 3, and 4.
4.
Yes.
So far, 3 and 4 are concerned. 109 and 366. Section 366.
3 and 4.
4.
3 and 4.
109 read with section 366.
109 read with section
366. 4 years.
366. 4 years.
So for appellant 1 is concerned, conviction under section 366 and 376. 366 and 376.
376. And
376, 7 years, and 360, 4 years.
7 years. 4 years. Yes.
But in this case, my lord, Pidol 2 is the victim in this case. She stated that while she was cleaning the utensils, by the time the appellant went there and forcibly taken her, gagging her mouth, and taken
You're on which item?
8.
8. Who is appearing 8 above? Let's see. Who will appoint amicus curiae. Deepak Mishra. None appeared. B.S. Tripathi. What is happening? Justice Deepak Mishra has spoken now, I said. Just imagine, huh?
His name is there.
Ah. So his appearances are also there.
That name. No. If I US appellate, 2 years conviction. I will intimate BS. DKs are in our panel. I will intimate the BS department.
B.S. Tripathi, last time his appearance is there on the request of Mr. Tripathi, Land Council preparing for the this matter is leaked. You ask Mr. B.S. Tripathi or telephone him if he can come. We'll finish it. It's a very small matter. Very small matter. We can do it. Ask him at 12 o'clock if he can come. Then we'll sit at 12 o'clock. Call him at 12 o'clock if he can. Okay. Which item?
So, for D Naik and Associates, we have 6 items, but Lordship, I'm prepared well in item 37.
37.
There's 12, 18, 21 also are there, but
12, 18, you concentrate the matters of 90s. You are choosing the easiest matter.
no, sir, item 12 is 376. Your Lordship, I can place the matter half also, but it is a 376 matter, so I need to research further because
See, 95 matter. 95.
Lordship, I am
Appeal, yes.
prepared in
Next,
one item 37. achi.
And next item?
18.
18 also 95. Appeal. You want to do 37.
37 sir, jaldi solve jai.
Jaldi kare katha nahi. 2003 matter you want to do. 95 matter you will not do. What
No,
is
so I will do all.
No, you start 95 matter.
95.
Some 95 matter, which one you want to start, you tell me.
95.
Many matters of 95 you are from your office.
Vijay Kumar
Vijay Kumar, item number?
But your Lordship, may kindly allow me to do part third. I will
It's all right.
conclude the rest.
No, I'll not conclude like that. We'll, to your satisfaction, you argue, no problem.
Your Lordship.
We'll read together, don't worry.
Lordship.
Which item you want to do?
12, Vijay Kumar Kundu.
That is item 12. Very good. You start doing it. Ready, get ready. 12 o'clock, huh?
12 o'clock.
Just read. And
Right.
period undergone and 376, huh?
376.
Period undergone and all these things, you just check it up. Okay.
Your Lordship,
12
item,
o'clock I'll hear it.
item 11.
11, yes. You ready? Then I'll hear item 11 first, thereafter you are.
Lordship.
Okay. Get ready.
Item 46.
Which year?
26.
Hmm?
2006.
Wait, 2006. 95 I'll first.
Madam.
Huh?
Lordship, item number 24. Now, before vacation, Lordship has heard it substantially.
24,
Item 24, 1999.
99. We
Yes.
can do it. You argued it?
Yes, your
You
Lordship.
argued, huh?
I argued in the before vacation, Lordship. You have heard it.
Okay, then what I'll do is, first of all, I'll hear 11. Then your matter. And Mr. Naik, huh? No, 12, he is not confident. Mr. Naik is. Okay, 11 first I'll hear. Thereafter, 12,
20.
then yours, huh?
Lordship.
Your matter is already part heard, huh?
Yes, your Lordship. Prior to vacation.
So why then there must
1 year conviction, 91 days period undergone all.
91 days?
91 days conviction.
Twenty-four, huh?
Lordship.
1 year. Conviction 91 days on road.
Means about 3 months. 3 months undergone. 91 days. 1 year sentence.
58.
What is the age?
59.
65 years.
Lordship.
498, hai na? I'll grant probation. Why are you? Shall I grant probation? I grant probation and finish it up.
Up to
No, see, 65-year-old. Let us see what is this. Appellant number 2 died.
Appellant number 2 died. One is approximate 58 years. Appellant number 3 is 75.
Oh.
The daily laborers.
Convicted under 498A. only.
498 only.
Well, do you have any problem if I give you probation?
No, Your Lordship.
I'll give probation. I'll give probation by maintaining conviction. Age, see the age of these people. There is a probation there. I'll allow, madam. Partly allowed.
My lord will hear me today, 46.
No.
Or
The other
Shall
witnesses
I-
are lined up.
Shall I
I'll just give you probation, okay?
Lordship.
There's an file. There's a probation. Probation, huh?
Amicus curiae.
No, the नाम
Swagata Lakshmi Singh.
लिखा है इसमें, okay. Thank you very much. Okay. I'll come at 12. 11 and 12, huh? Thereafter.
Item 11.
304 part 2.
Yes, Your Lordship.
34.
Lordship, FIR was registered under section 307 and 34 IPC. Subsequently, the injured expired in the hospital and the police submitted charge sheet under section 302 and 34 IPC. And the lower court found them and convicted them on 304 part 2 and 34 IPC
Yes.
for 5 years rigorous imprisonment.
Yes.
The alleged incident took place on 28/1994 and the death occurred on 22nd
$90,000 each. Default one is 6 months. Okay. And
Thursday.
because at 2 o'clock I'll hear Mr. Dhal.
Thursday, my lord, Thursday, more out better.
Tuesday.
Tuesday.
You get time also too.
Yes,
Yes. Yes, Mr. Mishra, do you have any matter?
Matter, my lord. 2012 Patad matter, my lord. Can it be taken? 2012 Patad matter, my lord.
Listed today?
No, my lord, not been listed, my lord. Can it be taken? My lord?
Oh, once it's listed, then only you can do it.
Pass over item 3.
Then happy to.
Receive.
Look, wide 3, na? Wide dot dated 5/1/2026. this court, while allowing the VLAPL number 13791 of 2025, admission of the petitioner on bail. The Learned Counsel appearing for the petitioner had made a specific statement that the petitioner has no criminal history. Taking into consideration the statement made by the Learned Counsel for the petitioner, although the bail was granted, but a condition was imposed that he shall be released on bail subject to verification of a similar type of antecedents. Now the application, now the petitioner has moved an application seeking variation of seeking modification of the said condition. He has filed an affidavit, comprehensive affidavit, disclosing that in fact the Learned Counsel for the petitioner has filed an affidavit, his own affidavit, stating that he made the statement regarding statement that the appellant, the petitioner has no criminal integrity on the basis of instructions he received from the briefing counsel. The affidavit is taken on record. Who has filed this affidavit? Comprehensive affidavit. The wife of the petitioner has also filed a comprehensive affidavit indicating that the petitioner is involved in two cases. However, petitioner is involved in two cases. However, in one of the cases, he has already been acquitted by the trial court, and in other case, he has already been in other case, notice under section 41 capital A CRPC has been served on the basis of the aforementioned. The counsel for the petitioner raised for modification of the condition regarding head to the affidavit. And the informant has also filed an objection affidavit objecting to the modification of the condition as sought by the petitioner on the ground that the petitioner has in fact involved in two cases regarding head to the affidavit filed by the respective party and counsel for the petitioner. And the fact that the petitioner has already been acquitted in one of the cases registered against him, and in other case, notice under section 41A capital A CRPC has been issued. 41 capital A CRPC has been issued, served upon him, and he was not taken into custody in that case. I'm inclined to modify the condition. Accordingly, the condition imposed by this court by order dated 5/1/2026 that the petitioner shall be released on bail subject to verification of a similar type of incident is expunged from the order dated 5/1/2026. The rest of the order remains same. The rest of the conditions remain same. Yes.
I'm extremely sorry, but I don't know. I was in hospital, my wife had a minor operation.
What did I do?
Modification to
Okay, what was the modification?
What is the order person? The FIR number is wrongly written. It should be 75.
70?
Para number 3.
Para 3.
Yes.
PS case number 74.
Yes.
It is written.
75.
Let us see in the
This FIR is there, madam.
FIR is there.
There 39.
75. Same code. Huh? And 75 crore, huh? 74, huh? The FIR number is to be changed. Okay.
Okay. Sorry.
Yes.
Item 6.
Wait. I have got this question. I got a senior argument very well. I have married good case. But the
While he was 6 years old in the real professional in that case, my lord.
Therefore, he remembers it.
My lord.
Which paragraph?
6 and 8.
Yes. Please read it. Next.
Medical scene. The result of the radiological test, the X-ray report showed that the fishes for kernel and the algae and they appear and had appeared and not fused. The table given at page 178 of Fox Medical
Toxicology of
toxicology. Sixth edition shows the time of union of epiphysis of different joints of so far as the calvic in concern is concerned. The fusion of the sternal and takes place between 25 years and 28 years. But in the present case, the fusion had not taken place, though the sternal end of the calvicle had appeared. From this, definite opinion cannot be reached regarding the age, though it can be certainly be said that the gal was beyond 17 years. The test also showed the epiphysis or tip of a crocodile process and acromion of a scapula had appeared and had fused. The epiphysis for a head and a humerus had appeared and had partially fused. The reference to the table shows that a union of epiphysis of acromion takes place from 18 to 19 years, and the union of epiphysis of the humerus takes place between 19.5 to 20.5 years. According to the table, the union of such epiphysis takes place between 18 to 19 years. In Episode 1, according to the report, epiphysis for distal end of radius and the ultra had appeared and had partially fused with their respective surface.
Last three lines are important. It is notorious fact that in our country, the correct date of birth never discloses to the school admission register of a fact and which is noted by the Supreme Court and so on. So the conflicting evidence of the school register as regards to the age was not acceptable in view of the more determinative evidence of the radiological examination and other physical characteristic available for ascertainment of the age. And next paragraph you said 8. So far as this aspect is concerned, the evidence of political officer who examined may be examined. People one made a statement.
Maybe examined people one. Made the first statement before while he was taking to the history of the case. Before him,
voluntarily
he had categorically stated to have voluntarily fed away with the applicant. He had not voluntarily. On 793, Dhawanagiri and Konark having married him and then fled away to Berhampur and remained there for 10 to 12 days and to have again come back to Bhubaneswar when she was caught by police. This statement made by her almost strikes the death nail and against.
But there the evidence was different.
Not different, but only difference in she remained with the prisoner 8 days. Here, my lord, say the victim remained with the prisoner 2 months, my lord. Only difference is, my lord, she stated that with regards to possible intercourse, the present case he has not stated. In my case, my lord, she has stated that a prisoner.
But the finding here is the girl has prevailed over the boy to marry her. But here the evidence is contrary.
Difference between 1 and 2, they have an example. Difference between 1 is the grammar key, and 2 another witness. They stated that there was a marriage proposal. The father demanded a 5,000, but they are agreed to give 2,500 for that is the false case industry. Because did 1 and 2.
DW1 and 2.
1 and 1 is the number key. If he is one of the rest,
That you had put suggestion to the prosecutrix also regarding that.
and with regards to this decision, both the decisions to declaration matter.
Only you are emphasizing on the age of the girl. And if the age of the girl is taken to be 17, then the consent part can be inferred.
The IO put question to the IO. The doctor who has examined, radiologist doctor, we don't find. He stated that it can be variation of 2 years either side. If he specifically stated that the age of the victim is 14 to 15 years.
Another judgment of Honorable Justice J. Das, Jogeshwar Das, is there. He, after referring Honorable Court, or after referring Supreme Court, that 65 Supreme Court, 70 Supreme Court, I said, there is a term called age of discretion.
Yes,
Carl has reached at the age of discretion on 15.
That he has, this judgment, if you can look into Madras, 65 Madras, if you get it, age of discretion, you will get it.
Yes, that age of discretion.
Age where the girl has attained the age of discretion. Age of discretion.
That says they use
And had prevailed over the boy for marriage. You have to bring your case to that bracket. Age of discretion.
So the age of the doctor, admittedly, the section 35, entry in school and register, that is not arranged under law because that is not the date of birth. They are not given while admitting the victim in the school. And the person who has admitted the victim in the school, he has
Not examined.
Only the headmaster examined. He stated that
you also get the age of discretion of the girl by reading PW5 and other evidence. Prepare a note of submission and give. And issues are there. Prepare a very good note of submission regarding this. Because you have a very difficult case. If you want to get benefit, then you have to labor hard. You do it, do it and show it to him and bill. Thank you very much. Yes.
Item 7.
Aram se, let him give. Take your own time, but get a good this thing. In that age of 1965 judgment, you see age of discretion. What is age of discretion? In the evidence, available evidence, whether you are falling under that category or not. Yes. Page item 7.
Great page. Yes. Here the appellants are 2 in number. Well, they have been convicted for the offense under section 304 part 1 of the Indian Penal Code and sentenced to undergo RI for 5 years and 452 for 4 months and to pay a fine of rupees 1,000. Well, here case is that the appellants and the deceased appellant and another who has been acquitted, they are the relations of the deceased. They had some sort of land dispute earlier to the incident. As Ballard, the deceased used to take drinks by the liquor, and to meet the expenses of the liquor, he was in habit of selling the land, paternal properties.
Okay.
So there was some sort of dispute. That is the admitted case of prosecution in the affair. Violent to substance, and on the date of occurrence, it is alleged that while the deceased was in his house, the appellants and another who has been acquitted, his name is Pinaka Kahara, they all came, assaulted him by means of lathis, his blows, kicks, and he sustained injuries and ultimately succumbed to the injuries. But trial court was pleased to convict the appellant. Present appellants 304 part 1 acquitted the other accused, reaching at a conclusion, even disbelieving the so-called dying declaration The statement of the deceased was recorded by the investigating
161
officer,
statement is 161 statement. Yes.
which has been exhibited as Exhibit 21. But to substantiate the allegation, the prosecution has examined around 14 witnesses. And out of the witnesses, all the witnesses, including the informant, kept on hostile.
No.
And only PW5 has stated that after hearing the occurrence, when I reached the house of PW5, the next day, PW5 was sitting in his house and he stated that I have been assaulted by 3 persons, but one of them have been acquitted. In the cross-examination, he has candidly admitted that when I reached his house morning, he had consumed liquor. He was he was in drunken state and stated me about the involvement of the present appellants. The doctor who has examined the deceased, well, let me see this, because in the present case, bereft of the evidence of PW5, the evidence of PW10, 11 are important.
Doctors.
Yes, madam.
Yes.
PW10 is the first doctor who had attended. Well, I may see paragraph 3. On examination, I found Sima Kahar was a SEBI past delirious
Sima Kahar is disease.
Well, the appeal and the reactions to like present. So I suspected head injury, the type laceration. His pulse was 78 per minute. His blood pressure was 80/50. Of mercury. I
X-ray of the skull.
advised X-ray of the skull, which could not be done. Sima Kahar died at the next day at 1:40 p.m. Sima Kahar was able to talk. This is the valid ticket of
Pulwani
Hospital marked as Exhibit 11. Exhibit 11 by 1 is my endorsement. Sima Kahar was admitted to the ward or 29/9 also. Sima Kahar by the time of admission was conscious and able to talk. On 22/12/93, I received this requisition marked as Exhibit 12, wherein I was asked to answer if I was the treating physician and if it was I was the treating physician, why I have not recorded the dying declaration of Sima Kahar, knowing it to be a medical legal case, and that how I failed to inform police to the receipt of medical legal case in the hospital. I answered to that letter by furnishing this letter, drawing of my own handwriting. Exhibit 12/1, 12/2 is my signature. Cross-examination has been declined. So exhibit PW11. Postmortem doctor. I conducted autopsy of the dead body of Sima Kahara, son of Rima Kahara of village so and so. I found the following external injuries on the person of the dead body. Contused abrasion, 4 inch into 3 inch on left peptal fossa, backside of the knee. Contused abrasion, middle size of right knee. Fracture, deformity of left knee. Contused abrasion, the forearm. Contused abrasion, 2 inch into 3 inch on the left side of the left elbow. Dislocation of left elbow. Lacerated wound, 2 inch into 3 inch on the left thumb. Abrasion, 2 inch into 3 inch on the left buttock.
There are many injuries.
Are not on the vital part of the body. But then question comes up, why he succumbed to the injuries? Next balance, disease. Surrounding tissues containing heavy fatty particulate near this tissue of the left elbow contains heavy hematoma. About 100 cc clotted blood found in the joint capsule. There was dislocation of bones, the left elbow, all the organs slightly congested. All the wounds are antemortem in nature and might have been inflicted by heavy blunt weapon. Cause of death is fat embolism. That is important, right?
Cause of death is fat
Embolism.
embolism arising from the
Multiple fractures
fracture
mentioned above.
mentioned above.
Time since death 24 to 36 hours at the time of postmortem examination. This is my report drawn in my own hand, so and so. My lord, OIC PS sent this letter to me seeking answer to regarding admission of death of Sima Kohra. Exhibit 14/1 is that letter. I submitted my reply to the police officer by this letter drawn up in my own mark. Exhibit 14/1, 14/2 is my signature. I had replied that I was not the treating physician of the patient, Sima Kahra, except on call for attending emergency, and this patient was unconscious and gasping to enable me to record the dying declaration. On 10/11/93, I received this requisition while sending the axe and lathi MO2 to me. I was asking to supplement further my postmortem report with reference to the probability and about 2 and 3, the injuries found by me. I submitted my reply by this letter number drawn by from my so and so by exhibit 13/2, 13/1 is my signature. I had affirmed that injury number 1 is possible, the blunt side of the axe and by the lathi, and injury number 9 possible by the lathi sent to me. Next is very cross-examination method. MO3 may cause all external injuries. In this case, this is the Sima Kahra
Could not have lost
his sense in the place of occurrence and subsequent thereto. The complications that arose for heart embolism could have been on the patient could have survived if timely treatment could have been imparted. I collected 100 cc of blood from the elbow area only and not from the other parts of the body. Some of the injuries are possible by fall. All injuries cannot be possible by fall. To quote, at one stage you had said that the patient could have survived if you would have given imparted timely treatment. In this collection, you will agree that the patient was under treatment in your hospital by the exhibit 11 and beforehand was under treatment at Balangopada Hospital by the exhibit 10. How would you reconcile that the patient was not timely treated? Answer is timely treatment is immediate after receipt of the injury. The patient should have rested. Here, PW5 says he was very much available in his house. Nobody has informed, nobody has taken him. On the next day morning, he had gone to the house of the deceased and found that he was sitting there in his house in a drunken state with spleen of injured limbs, and the patient should have been remained in constant static position without jerk by using of these splints, that is transportation of patient to hospital should have been made without any jerk of any part of his injured limb. Well, I was going through the literature on this subject. What is fat embolism? Well, that occurs if fat reserves in the body, say fatty liver. If some cracks occurs in the body and the what is that blood? No, that liquid, that body, bone marrow, like that sprayed over the body and touches the fatty portions, that creates a problem. That Bodhi has said, in Bodhi's jurisprudence, it usually occurs 12 to 48 hours after injury with tachycardia, tachypnea, fever, confusion, stupor, coma, convulsions, and petechial rash on the upper anterior portion of the body. trauma to bones fracture is the most common cause. Other causes are trauma of soft tissues, injury to pelvic tissues during childbirth. The non-traumatic causes are extensive burns, fatty liver, diabetics, mellitus, and therapeutic introductions of fat or oil into the body. Injury is due to mechanical obstruction of blood vessels and biochemical injury to blood vessels and blood components. Diagnosis is confirmed on histopathology by demonstration.
No,
of
what is your attempt? You are saying that it is not a homicidal one.
It was not homicidal. If proper treatment could have been given, he would have survived. And basically, the gas embolism says if a person is a drunkard, that affects very quickly. And
What is the material?
doctor has neither the postmortem doctor nor
both of them have not said that.
nothing but.
And where from you got that he was
That he is
five have said.
PW5 has categorical
Let us see 5 about 5.
And PW1 has PW1, wife of the deceased, has also stated in that line. Well, let me see the cross-examination part, page 49.
Page 49, huh? Yes.
Paragraph 5. The
Informant.
house of the accused person is situated.
Informant, huh?
My lord?
House, yes.
Page 48.
At a distance of 2 miles.
These houses are situated in one side. I have houses of Lamba for Kahara, Raja Kahara, and my houses are situated in one place, intervened by a distance of 50 to 60 cubits. The houses of Karnahi Karnar is about 2 pillars from my house. My husband was accustomed to consumption of liquor. On the occurrence night, my husband had suffered from fever and accordingly had not consumed liquor. And the previous day of the occurrence, my husband had gone to village Resu and quarreled with the accused persons. My husband had sold the villas. The accused persons were always telling husband not to sell the land. My husband, after consumption of liquor, had several encounters with several villages. It is not a fact that my husband was not in a good terms with the neighbors, my husband, and so on. So admittedly, he was a drunkard, and the date of occurrence also, on the next day of occurrence, when PW5 visited him, he says that he was in a drunken state. PW5, page 57, cross-examination. Paragraph 5. I put the signature in Exhibit 6. Of Arendipot outpost. By the time Sima Kahara was talking to me, Sima Kahara had consumed liquor. And his wife was also present as per the version of PW5. While he was talking to PW5, PW1 was also present, but PW1 has turned hostile. It is not a fact that I am deposing falsehood. By the time Sima Kahara told me the wife of PW1 was present, also present besides her husband.
Then PW1 and 5, 10 and 11.
Well,
1, 5, 10 and 11 are the relevant.
Well, one is not hostile. One is not hostile. Only PW5, vis-a-vis Exhibit 21, the previous statement of the deceased, which was recorded under 161, and after his death, that has been taken.
He was drunk by that time.
Drunk by that time.
Yes, what do you say?
But on the date of occurrence, he was not drunk.
That PW1 says.
Yes. Their cross-examination. And so far as the evidence of the Dr. PW10 shows that he was conscious and was in a position to talk. So there is no reason to disbelieve the version of PW5. Even if it was a case of assault, all the injuries are grievous. Even It may be a case of for the 320. sake of argument, I am not considering. Even if 300 for part 1, 325 will be attacked.
Yes, sir. The earlier case, I did the same thing.
Here
These are
the
for
same
part 2, I said 325 maximum.
It may be fine 1,000.
There is no evidence are not so, convincing evidence. What is the age of these people?
But at present, there will be 60, 58 and 60. Champekar would be around 58, 59. Appellant number 2.
Champekar 58 and the other one is 65.
65.
Champekar 65, Ishekar 58. Both are well and residing at village
Which is
with
elected.
their family.
Exhibit 21 is the
Consistent statement of this.
what is the period undergone so far?
They
Around
were arrested on 1/10/1993.
1?
1/10/1993, forwarded and remanded in custody on 2/10/93.
Uh,
They were released on bail on 4/11/1993.
4/11?
1993.
93.
Thereafter, from the date of judgment, they were in custody. Released on bail by this honorable court on 6/6/1995.
6/6/95.
And bail bonds were submitted on 12/7/1995.
only 3 months, 3 months, right?
92 days.
3 months, approximately.
2 days.
May 95 ରେ judgment ହେଲା କେବେ ଗଲେ?
ଗଲେ bail 6/6/95 ରେ released on bail by this honorable court.
Then here in the during trial, about a month. About a month, okay? About a month. And after the judgment, conviction, about
1 month.
2 months.
That's because they after they released on bail, they submitted bail bond in the month of July. Eh?
July, 12th July, 12th July. So May to July.
12/5/95 to 12/7/1995.
About 2 months to 3 months. About 3 months.
3 months.
About 3 months.
Fine, minute, 1 month. It may be advanced.
About 3 months.
Swap.
Hmm?
Senior is suggesting to enhance the fine amount. If the
5,000 କରିଦେଲେ ହବ। But କିଏ ନବ ଆଜିକାଲି ସେ ଏତେ ବର୍ଷ ପରେ it's around 30 years, 31 years.
That's the
And nobody is
biggest problem.
responding also.
Huh?
I'm ଜାଣି ବି ପାରୁନି କିଏ ସେଥିରେ
He or
ଅଛି।
she informant is surviving or not, who knows? The wife of she was 38 years that time.
Because after
Date of incident.
2-3 adjournments, it could be ascertained that they are elite. So
No, the informant or the LRs of the deceased, anybody,
it can be said.
that is the informant or the
LRs.
wife of the deceased or LRs.
Mallet.
So we'll reduce down to 325.
19 19. What is it? Criminal appeal.
government appeal
Government appeal
time
movie ଅଛି.
There is no eyewitness to this.
Only PW5 person who says after hearing about the incident, I had gone to the house of deceased in the next day morning.
Only then the deceased himself has said that I was beaten by these people. And he was completely drunk.
His wife
And one of
Right,
he has
And
taken.
so many injuries were found. And one sentence in PW1, just see, PW1 says, suggestion was there, he's quarreling with everyone.
He's quarreling with everyone.
Just in the cross-examination last 49, if you see, my husband, after consumption of liquor, had several encounters with several villagers.
ସମସ୍ତେ ଜାଗାରେ
କିଏ ତାକୁ ମାରିଛି କଣ କରିଛି who knows?
The date of occurrence he was not wrong. They had also in
The occurrence means with whom the occurrence has taken place. Any villager may be. The only strength is that is 161 statement of these disease which was recorded.
And that has also been partly disbelieved because he has taken 3 names. One of them has been acquitted.
the ground that the wife of the deceased who is being done, she has not attributed any overtime to that. Actually.
What is the motive then? Motive?
Motive वाला dispute with land dispute. घर ताको भीतर they are cousins.
Weak evidence. Very, very. Exhibit 21. Exhibit 21. Yes. Item 9. Yes.
It's 38 into 2,000.
Yes.
Basically,
Three of you.
Total.
Karunakar, Niranjan and Adudev.
Adudev.
Hmm.
They have been found. Number 3% sort of
Yes. FIR.
ଜଣେଇବାର କାରଣ ଏଇକି ଯେ ପ୍ରାୟ 10 ବର୍ଷ ତଳେ ଆମର ଭିକାରୀ ଅସୁର ମୋର ଟଙ୍କା ପ୍ରାୟ 2 ଡେସିମଲ ଥିବା ବାଡ଼ିକୁ ଗୋଟେ କିଣିଛି ସେଗୁଡ଼ିକ ଦେଖି ଭିକାରୀ ଅସୁର ଠାରୁ 3 ବର୍ଷ ଥିବା ଗୋଟିଏ ଘର କିଣିଛି କିଣିବା ଦିନଠାରୁ ଉକ୍ତ ଜମି ଓ ଘରକୁ ନିଜ ଅଧିକାରରେ ରଖି ଶାନ୍ତିରେ ଚଳି ଆସୁଥିଲି ଆଜି 28 ରବିବାର ଦିନ ପ୍ରାୟ 5ଟା ବେଳେ ମୋର କାକା କିନ୍ତୁ ଜମି ପାଖରେ ଗୋଟିଏ କାଠ ଦେଲି କରୁଣାକର ବେଶୀ ନିରଞ୍ଜନ
କରୁଣାକର ଯୋଶୀ ନିରଞ୍ଜନ ଆଦିକନ୍ଦ ଯୋଶୀ
ଜୟଦେବ ଯୋଶୀ
ଜୟଦେବ
ଭାଗବୀ ଯୋଶୀ ହଠାତ୍ ବାହାରି ଆସି ମୋର କାକା ଦେଇଥିବା କାନ୍ଥକୁ ଭାଙ୍ଗି ପକାଇଲେ ଏବଂ ସେଇ ଜାଗାକୁ ସେମାନେ ନିଜ ଜାଗା ବୋଲି ଦାବି କଲେ ଏହି ସମୟରେ ସେ ସ୍ଥାନରେ ମୁଁ ମୋ କାକା ସାରାଙ୍କ ଦ୍ୱାରା ହତ୍ୟା ସମ୍ମାନ ମାଝୀ ହେମନ୍ତ କୁମାର ଯୋଶୀ ରମେଶ ଚନ୍ଦ୍ର ହତ୍ୟା ପଦ୍ମିନୀ ହତ୍ୟା ଜିନିଷ ଜ୍ୟୋତିଷ ଚନ୍ଦ୍ର ହତ୍ୟା ସେଠାରେ ଉପସ୍ଥିତ ଥିଲେ ଆମେ ଆଦିକନ୍ଦ ଯୋଶୀ ଏବଂ ତାର ଲୋକମାନଙ୍କୁ କାନ୍ଥ ଦିଆଯାଇଥିବା ସ୍ଥାନ ଆମର ବୋଲି କହିଛୁ ଏବଂ ଆମର କାନ୍ଥ ଭାଙ୍ଗି ଯିବାରୁ ଆମେ ତାର ପ୍ରତିବାଦ କରୁଛୁ ସେଇ ସମୟରେ ଆମ ପାଖର ଭଦ୍ରଲୋକ ଉଜ୍ଜଳ ନାୟକ ରେଷ୍ଟ ଅଫ ଦି ଲିଭିଗେସନ
ଠିକ ଅଛି
କାମ ନକରିବା ପାଇଁ ଖବର ଦେଲେ ଏହି ସମୟରେ ନିରଞ୍ଜନ ଯୋଶୀ କରୁଣାକର ତାଙ୍କ ଘରରେ ରଖି କରି ଭାଗିର ଏସ୍ତ୍ରୀ ଗାଡ଼ି ସେମାନେ ଖତମ କରିଦିଅ ବୋଲି କହିଲେ ଭାଗବୀ ଯୋଶୀ ଘର ଭିତରୁ ପ୍ଲାଷ୍ଟିକ କିଣି ନିରଞ୍ଜନକୁ ଧରାଇଥିଲା ନିରଞ୍ଜନ ଯୋଶୀ ସେଇ ଏସ୍ତ୍ରୀ ଧରି ମାରିଦେବା କହି ଆମ ଉପରକୁ ଏସିଡ୍ ପକାଇଲା ଏବଂ ଆମମାନଙ୍କୁ ଘରକୁ ଯାଇ ସେଇ ସମୟରେ ପୁଣି ଏସ୍ତ୍ରୀ ଧରି ବାହାରକୁ ଆସି କରୁଣାକର ଯୋଶୀକୁ ପ୍ରବର୍ତ୍ତାଇଲା ଏବଂ କରୁଣାକର ଯୋଶୀ ଏସ୍ତ୍ରୀକୁ ପିଲା ସେମାନଙ୍କ ଉପରୁ ସକାଳେ ଜୀବନରେ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ପକାଇଲେ PW, the number of PWs, PW9 is the injured height.
9.
PW9. Paramodara doses. 2 persons first and religious issues. Paramodara and Tormis.
PW9 and
PW9 is the injured height.
only one injured was examined.
One and 9.
No, who are injured? And 9. PW1 and 9 injured. Okay. Yes. PW9. Yes.
This occurrence took place on the Sunday, the date 28/3/93. I purchased one Marie land from Vikari Joshi in the year 1992 measuring 2 decimal acquisition. The accused Adikanta purchased one homestead land in rooms of the house. Adikanta and my Machian uncle said, I asked my son Ramesh Chandra Gupta and my field servant Sana Mantri to raise your bar close to the passage in between purchased land of mine and purchased homeland Adikanta. When my son and Sana Mantri were constructing the work, accused persons gave an objective name all the accused persons. Thereafter, unless inform the accused of the accused person, I use the spot and explain the accused person that the wall built in my land was not affecting the possession of which I should not object. The accused person said to possibly grab 3 to 4 cubics of the land, a construction in a passage. They expressed my inability to use the land with the passage. The accused persons abused me
broke the wall.
Broke the wall. Then I went to court 5 of but they are Anducharan Joshi, between their cases, Ujjwal Nair,
So and so. The advice is not to correct. Huh? Not examine.
Their advice was not to correct. The accused person did not listen to their advice and further thereafter threatened to prison and family. The Bhadralokas again advised him not to continue the construction of the refusal of the RI and on which still the accused person were threatening and abusing. Accused Harudava and Kavanakar called their mother. Their mother come with 2 bottles of acid, 1 plastic mug. Kavanakar Joshi is a goldsmith professional. August Madhavi Joshi came to the spot and the opposite properties because Kavanakar and Harudava called her asking her drink acid and mug. All these things were displayed by the lower court. Niranjana Joshi came to the Niranjana Joshi came with a similar lathi. He dealt a blow with his lathi on my left shoulder, point to the left shoulder joint. When he was taking the second blow, Kanmu Sarana Joshi objected to the blow and wanted to snatch away the lathi. As a result, he received blow on his face. MC excites the semi-stick which was I was assaulted. MO2 is the plastic mark and inches 3 and 4 are the waters with lady accused. These facts are also displayed by the lower court laws. Niranjan Doshi, MC Excite went to his mother and asked for acid. Bhargavi poured some acid in a mug and gave it to Niranjana. Accused Niranjana peeled acid on my face as a result. I fractured bone injuries on my face, including the eyes, lids, and the face of the witness is distorted and left. Tina was damaged due to OC action. The acid I tried along Marili. Again, Karnataka, the sheet you acid means saying slow. The acid fell down on my left shoulder, right arm, and my right hand. The witness exhibited the bottom parts of the came in a bare body with your in around. And again, I tried so and so. I asked the water to wash my body. After washing my body, with my dress was changed, and I was taken to hospital. At the time, I was wearing blue onions and check room. Mostly, I is my lungi. First, I was taken to Volunteer Hospital. Then I taken to 52 Hospital. Thereafter, I was taken to Urla Hospital. I was treated there for 1 month and 5 days. I was referred by police. Plastic structure was made in the skin and the leg was planted. The right hand, I discharged Urla Hospital 5/93. Police examined me and discharged from the blue. I discharged from Urla.
So who is doctor?
Doctor is 4 and 5. 4 and 5. And the assistant professor BSc Medical College, Gujarat, Already Dr. Gopasio was referred to me from casualty 31/3/93 at 10:40 p.m. On my exemption, she was enrolled person of BSc Medical College in my eye department. She was admitted to bed number 10, female one. She was hosted, received work on face and shoulder.
This is he treated PW?
One. She thoroughly PW1.
Treated PW1, huh?
The war was about 15 to 20%. To what is do you mean by percentage of war? The entire body is taken 100%. The extent of effect this one is to chop out from the state. He has injuries on the upper wrist and side of the face with secondary infection. The age of the injury is to 3 to 4 days. The rest of the injury is serious. Exhibit 1 is my report and exhibit 1 by 1 my signature. He stayed in the hospital for more than 20 days. On the same day, I examined Sananda PW9 University. Son of Hadigar Gupta, report to casualty. He was also admitted to Indore patient. It was neck, face, plate, and shoulder, right from the forearm. Both the eyelids of the patients were extensively exposed and developed
And permanent deformities. I found
Contracture and permanent deformity.
permanent deformity. I found secondary infection in all the wounds. The nature of injury was vigorous. He stayed in the hospital for a moment. The age of the injury at the time of the examination to 3 to 4 days or 4. Exhibit 2 is by report. 2 by 1 is significant. The still box with particular place of the body do not leave any mark of injury infected on the
Okay, I got it. What is your case?
Well, my case is only 30 years of past. You will personally release on probation of offender act your lawsuit.
No, see, acid attack, permanent deformity.
The year of 95 years. 95 is
Permanent. See, 2 days back there was a judgment of Supreme Court.
that is book 26 side. At that time there is only 326 lawsuit.
But you have seen that judgment, the reasoning.
2 days back.
2 days back. Supreme Court.
That's why I would say, next week I
No, what next week? Directly against you. No leniency in acid attack cases. That's the judgment.
3% as illegal. 326
And permanent deformation. And the PW1 will remain in the hospital for 20 days and PW9 remain in the hospital for 1 month or something date. And the doctor says that PW9 is permanent deform and insofar as PW1 is a lady, face, eyelid. And today in the newspaper also you will get that big article on this. The evidence is
one person has illegal. There are all the 4% also I use. 1, 2, 8 and 9.
and 82, just see 82, page 82, further cross-examination. Read it. The severity of the injury you can understand from there. See, read it. After receiving the reference from district headquarters, Hospital Bolangir, further examine Tarangini Hota, the girl, so and so, for expert treatment and
Our aunts were admitted the IWAD basic medical college Bulla so this is the where ticket of Saranganota in support of our medicine basic medical biomedical 20. She was admitted in Kajak and then shifted to IWAD. I was the resident surgeon of the IWAD on July on 2019. She was admitted in Kajak in the dead night of the 2019. So the registration of doctor investigated permanently remain in the ward as an indoor patient in 19. On that day, she was discharged with a poor very indoor of that it was a referred to medical legal department or hospital. The lecture of patient department going to examine the termination and submit a report which is available in the ticket. Here in the report in my presence of the different from the report of the doctor 3 months was the lecture of the products. I have in the report maximum where ticket to the congratulation on being a very difficult part of the Bolangir. Sarangin Hota, that is Sarandra Hota is the PW
9.
Yes, PW 9. Hota was admitted to the IWAD and the various medical process on a past frequent to Kajwal and they admitted into the US IWAD.
That girl was having eye injury.
1, 2, 8 and 9.
injured.
Other injuries are simple injuries. I mean the other
One and 9, 2 and 1 to
1 to 8.
8. Tarangini is PW1. Let us see what she says. Christian. Yes. She was a 22-year-old girl. The face is deformed and Bhargavi has been acquitted, huh? Who brought the acid basically?
And to DSP. Bhargavi brought the receipt in a bottle and gave the receipt to the trustee mug to the Niranjan Doshi. Actually, Niranjan threw the receipt to the face of Saranandar. Saranandar tried. Then Niranjan handed over the box to his brother Bhagirathi Doshi. Again, Bhagirathi gave some more receipt to the same mug to Karunankar, to the same receipt to the Saranandar. The include Saranandar.
What is the reasoning Bhargavi was acquitted? Bhargavi brought the and he kept on giving in mug. Thereafter, in the mug also he gave it to secondary accused. First he gave it to Niranjan. Thereafter in the mug again he gave to someone else. And that was used. What is the reasoning? These people have thrown acid, no doubt. But actively participated. She got pace.
Let me now explain to the analysis of the evidence as against each of the accused persons and examine if the evidence is sufficient to sustain the charge against it. This discussion will make it easy to make the ends of justice. For the reason, I want to prefer the evidence available in the ADIP Bhargavi.
Which paragraph? Paragraph 5. Yes.
So let me now on to the analysis of evidence against the each accused person and to examine if the evidence is sufficient to sustain the charge against each. This classification will make easy to meet the ends of justice. For the reason, I want to take up the evidence against the ADIP Bhargavi. PW1 had not stated before the police the story about his report right from the stage of calling 5 gentlemen by Saranandara to solve the problem till the issue was thrown on her very hardly. This is apparently from her statement at paragraph 5 when her previous statement was confronted to her. In this connection, defense has also cross-examined the investigating officer who reported at paragraph 12 that PW1 did not state to him that Bhadralukko came and supported Saranandar, and the male accused person did not listen to him and threatened Saranandar to kill him. And the IU reported that she did not state to him all the subsequent events as stated by her in the chief till she was told to her by accused Bhargavi. The role played by the accused Bhargavi was also not stated by this witness to the investigating officer, which is one of the events of the incident stated by her in the chief. Hence, on the point of contradiction, the evidence of PW1 should not be relied on the implication of accused Bhagwani. The reason of the opposite huge contradiction in the evidence of P1 is that she reached the spot at the later stage, which is apparent from the examination of PW3 at paragraph 7. Here, the witness stated that Sana Naji and Dharanam Pradhan, two field servant, and Saramandara Ramesh, Saramandara Jyotish and small children were present on the spot beside the accused person. So he and other Bhadraloko reached the spot. So he did not say that PW1 was present on the spot when Bhadraloko reached at the spot. Therefore, PW1 did not state to the IO anything from very beginning of
Ideally, the only thing is he has not said those things to the IO. Therefore, we will not believe. That's what.
That's what.
Yeah. Reasoning is not.
Now let me go to the evidence of PW2 to stand if he had indicated
I've seen it. This is not a property loss.
Indicative accused Bhagwani and in one manner. PW Bhagwani's concern is I don't think she was alleged at the time she was 17 years.
So in any case, that there is no appeal from that side to then just I was just thinking. One?
170.
Yes. One?
There is a accused also. Medical officer of
117.
170.
Yes.
Of the district in the year 1993 on
Niranjan.
2890, I received a medical education from the police exam the CORAM district factory. I examined them and found some injury. I examined the university of it's from the following. Thank you.
Yes.
One was 22 at that time. And she was unmarried at that time. But the government could take instruction about her condition right now. Whether he's married.
Those are not the requirement. That is for the purpose of bail. We are considering appeal. Considering the appeal, you have to see the evidence. Evidence are there. How will you get over the evidence?
Give me one more.
Injured witnesses, all injured witnesses.
They are showing the proceedings law.
Very difficult case for you. And the trial court has given a very reasoned judgment. Dealt with each and every evidence, oral evidence as well as this thing. We'll continue Tuesday. Tuesday will continue. He wants to add. I don't have any hope.
ছোট্ট কেসটা আছে
I don't have any hope for you, but still, if you can substantiate this, we partly heard. Him part heard. Tuesday, huh? Tuesday partly part heard. Tuesday to top level. Heard it. Yes.
Here, my lord, the appellants are 11 in number.
Which one? Item
22. Conviction is, my lord, 307. Sentence is 2 years and fine of rupees 500. And with regards to 148, 1 year, my lord.
6, 8, 10, and 11 died.
6, 8, 10, and 11 died. Allegation is mostly on appellant number 1 and 2.
Shondere Bhoi.
Well, he is around 45, 84 years, and Lalu Bhoi. But if the case of prosecution will be accepted as it is, so it is alleged that Sundarji Bhoi, my learned friend, will also verify from the records. Appellant number 1 has been alleged to have assaulted PW6.
A1 to 6.
Well, and by means of an axe.
PW6, huh?
By means of an axe, but the injuries sustained are lacerated wounds.
And what about the other?
And the other man, Lalu Bhoi,
Lalu Bhoi.
He has assaulted, my lord.
A2. A2
has assaulted
to PW8. PW8, huh?
Right.
Okay.
And PW8 has sustained 2 lacerated wound.
5 and 6.
Sorry, 5 and 6. 6, my lord.
A1.
5.
A1 assaulted 5. 6.
5.
6 or 5?
5. And 6 was assaulted by Lalu. The injuries
A2, 6.
Well, the injury as per the doctor,
Doctor is PW
2. First is 2. 2 and 8. But allegation is very specific that appellant number 1 has used an axe, and witness has also at PW 5. PW 5, the injured, has stated the sharp edge was used. PW 5 says sharp edge was used, but injury is lacerated. There is direct contradiction with regards to the medical evidence and ocular evidence.
Insofar as
and with regards to PW 6, assault by appellant number 2, injuries are first injury number 1 is simple in nature, as stated by doctor.
But eyewitness is PW1 informant.
My lord. For that reason, I said if his evidence will be accepted as it is, appellant number 1 has given an axe blow to PW 5, and appellant number 2 has given a blow to 6. So, with regards to assault by appellant number 1 to PW 5, my lord would see the injury report because PW 2 is the doctor at page 60.
PW 2, okay. Yes, lacerated.
Lacerated wounds. All the injuries are simple in nature and probably caused by hard and blunt weapon within 24 hours of my examination.
And Para 2 says that these injuries could be possible by the sharp edge of an axe.
The edge was not sharpened.
Yes, this is Doctor
PW 5, because on the face of that the admitted fact of unequivocal relationship, and they are all relations. Well, at PW 5 says, I was not examined, I have not been examined by the police.
PW 5 is
I was shifted to Titlagarh SD Hospital from the hospital on production of PW1 by PW1, PMO1, travel, so and so seized. I had put at the time of assaults were seized. I was tracked in the indoor patient. I have not been examined by the police. It is not a fact that I have stated to the IO that the accused Sondarjia first assaulted me and thereafter my father was assaulted. With the accused persons, I had not concealed myself. Accused Sondarjia had asked, accused Lalu had rod and rest.
And who is the other doctor?
My lord?
Other doctor?
The doctor is PW10.
10.
Let us come to
He says injury number 2 injuries are sustained by PW6. The one lacerated is injury size 1.5 inch into 1 inch. And the second injury is fracture of and dislocation
Injuries are grievous.
of elbow, left elbow, fracture of upper end. And
Injuries are grievous.
it's grievous in nature and caused by blunt force impact confirmed by X-ray.
This Bhubaneswar Hans is PW 6.
6.
PW 6.
My lord.
PW 6. A2. But insofar as A1 is concerned,
My lord.
he has not given any grievous blow to anyone.
The
only thing
injuries
is-
are also not by sharp
That-
cutting.
But he has used the
So by the weapon
sharp side.
axe was attributed to him,
Hmm.
and PW5 says the sharp side of on the sharp edge of the axe assault was
This
made.
page 61.
It's a very
Come to page 61.
61.
Para 4. Doctor.
The injuries could not be possible by assault on the sharp edge of an axe.
Hmm.
Paragraph 4.
The edge was
The
sharp.
edge was sharp and not blunt. The sharp edge of the axe will be taken as a blunt edge. If it is
Lost its
sharpness, fracture may be caused depending upon the force used. If the assault is made with axe, size of injury depends on position of assault and blade and shape of the weapon used. The board question was
Assault on sharp edge of X.
PW5.
Sorry.
On the sharp edge of the axe, assault was made with much force. Late Mr. Mishra and Honorable Justice S.K. Mishra, they are conducting the case.
But sharp side has been used. Therefore, you say that there was no intention.
Sharp side has been used, but injury is lacerated. So, prosecution case is doubtful with regards to the injury.
No, if it is taken as it is, then you can very well say there was no intention. So, it will straight away reduce down 323 or 307.
It's a dispute. They have given a color.
But how will you
Get over PW number 2. That may be converted to 324. କେତେ ଦିନ ପରେ ଆଉ କଣ 23 ଦିନ କେତେ ଦିନ ଅଛି ଏମାନେ ଯାହା ବାହାର କରିଛନ୍ତି 15/7/96 କଷ୍ଟଡି ଯାଇଥିଲେ 7/8/96 ବାହାରିଛନ୍ତି ହାଇକୋର୍ଟରେ ତ ଯାଇନଥିବେ 2 ବର୍ଷ ହେଇଛି Justice Sanjay Mishra was taken as ADG. Right?
period undergone?
Justice Sanjay Mishra to happen. 29 days below. আয়ও কিছু করবে না।
Except 1 and 2, what are the evidence against other
How
people?
can
Yeah, this is 3, 4 and 9.
इंजोर तो कोण आधी किती
Injured ke kunad kichi. About these people. Sitaram, Prahlad,
PW3 has been taught hostile, my lord. 4 has been taught
Mohan.
hostile.
Rupodhara.
5
ଏମାନଙ୍କ ବିଷୟରେ କିଏ କହୁଛି?
ଆଖି ରହିଲା।
ଏମାନଙ୍କ ବିଷୟରେ କିଏ କହିଛି ଦେଖ?
ନାଇଁ ଆଉ କିଏ କିଛି।
Any witness?
8 ଆଉ କେହି କିଛି କହିନାହାନ୍ତି।
Then so PWA
କିଛି ନାହିଁ ସେଥିରେ।
ଏଇଟା is he injured?
ନାଇଁ ନାଇଁ ସେ କହୁଛି
Eyewitness.
Pilot see his evidence is on protest by my father. He was assaulted on his head and left elbow with rod by accused Lalu. Accused Sondarji assaulted on the head of Hajari with axe causing bleeding injuries. Hajari caught hold of the axe when accused Sondarji made a second attempt to assault him and he fell down senseless. Other accused persons had surrounded us and were shouting.
PW9 also. Accused Saundarya assaulted Hajari.
ସେଇଟା ତ ସୌନ୍ଦର୍ଯ୍ୟ
The Saundarya Lalu is there.
there.
But what about the other people? The other
Okay,
people are entitled to acquittal.
Entitled for it.
Others are there.
No verdict, nothing except this Waltz. Who was there? Other accused persons. And you are prosecuting as many as how many people there? 11 people?
11.
11 people. Merely saying that other accused persons were surrounded. That's the allegation. I don't think, except Saundarya and Lalu, I don't think anybody is.
Judgment also the London Trial Court has come to a finding that the accused persons except Saundarya and Lalu
एक ही करना।
are only surrounded the two.
That's all there.
निरंजन नायक सिद्ध करते
So 149, 30, 149. What is the period undergone?
ଏମାନେ ଯାହା ବାହାର କରିଛନ୍ତି 23 days ballot
Only.
man. Fifteen 7 15 साल ଦେଖିଲା या କଥା ଠିକ ଜଣା ଛାୟା ନା ବେଟା ହଁ ଲାଲୁ ପ୍ରହ୍ଲାଦ କଦର୍ପ ସୌନ୍ଦର୍ଯ୍ୟ ବେଲ ହେଲେ 7-8 ଛାୟା ଏମିତି ଦେଖିଲେ 7-8 ଛାୟା 7-8-96 Hmm? They sat as a judgment na.
He was arrested, Sondri was arrested on 15/96.
And
96.
released on bail on 7/8/96.
And he was 1956. Means he will be. Let's see what will be the his age. 1956.
When the Saundarya is concerned, is now 73 years.
Besi ho na.
56.
45 hitila.
The final form shows that his year of birth is 1956.
56. But Aadhaar card says 84. Accordingly,
Lalu 79.
as per the Aadhaar card, my lord, 1739.
39.
1739.
Aadhaar card.
They entered a doubt for which I had kept their Aadhaar card for me.
Is Saundarya. 39.
Well,
What about Lalu 64. Charge sheet says 79. Well, the Aadhaar card is there. Then if you go by Aadhaar card,
well,
he must be about
84.
84. Huh?
Around 84.
But here it is written 45 in 1978. 97.
हाँ
97.
I mean, say judgment upare base kariki judgment rachi 45. So we have mentioned 45. But when they
If we take 45, then what will be the
45 hele, in the year 97, it's around 29. 29, 74. 74.
74? And he
If it will be 35, 64 hour.
let us go by this.
We should go
64
by
and
judgment
74.
matter.
64 and 70. I think you can think of probation.
My lord.
Insofar as 1 and 2 are concerned with some fines.
My lord.
And other accused persons are entitled to acquittal.
My lord.
What do you say? Anything?
But the 307 probation sentence,
307 also probation can be given. You have their judgment. 307 also probation can be given. 397 appeal, they are in their 60s and 70s. 307 also, there are some judgment which says that you can give probation.
That I had given, my lord, it has been also taken note of by my lord. आइएगा
ये केस रहेगा
कोड़ा
आउट ऑफ केस
गवर्नमेंट ऑफ इट
ना सेटा तो चिंता
जोशी okay we'll do that pilot whether I will supply that judgment matter
give that matter. लिख दिया ठीक है कितना है